And welcome, you're watching NewsX with me, Devika Chopra. Vice President Jagdeep Dhankhar has criticized the Supreme Court's recent verdict that set deadlines for the President and governors to clear bills. Addressing the sixth batch of Rajya Sabha interns, Vice President Dhankhar highlighted that the apex court ruling invoked Article 142. The use of Article 142, which gives the Supreme Court extraordinary powers to deliver quote-unquote complete justice, created a first for India. Delivering a sharp critique of judicial overreach, the Vice President stated that India was never meant to have a democracy where judges function as lawmakers, the executive and even as a super parliament. Apart from this, VP Dhankhar spoke at stretch about the massive cash haul from the residence of Delhi High Court Judge Justice Yashwant Verma, slamming the judiciary's response to controversy. He underlined that no FIR has been registered against Justice Verma even after the recovery of cash during the fire department operation to douse the fire at his residence. The Vice President noted that a case can be filed against anybody in the country, but a special permission is required if a judge has to be booked. In the end, VP Dhankhar spoke about a can of worms that has now been opened up. Let's quickly listen in firstly to what he said, and then we take this conversation forward.
President of India is a very elevated position. President takes oath to preserve, protect and defend the Constitution. This oath is taken only by President and her appointees, the governors. We cannot have a situation where you direct President of India. And on what basis? The only right you have under the Constitution is to interpret the Constitution under Article 145(3). Parliament cannot script a judgment of a court. I have no doubt about it. Parliament can only legislate and hold institutions, including judiciary and executive, accountable. But judgment writing, adjudication is the sole prerogative of judiciary, in as much legislation is that of the parliament. But are we not finding this situation getting challenged? I am saying so because very frequently we are finding that executive governance is by judicial orders. When executive, the government is elected by people, the government is accountable to parliament. The government is accountable to the people at election. There is a principle of accountability in operation. In parliament, you can ask questions, critical questions, because the governance is by the executive. But if this executive governance is by judiciary, how do you ask questions? Whom do you hold accountable in election? Time has come when our three institutions, legislature, judiciary and executive, must blossom. And they blossom best, and best for the nation, only when they operate in their own area.
All right, so there you've heard it. I'm being joined on the broadcast by Senior Advocate Siddharth Luthra, former Additional Solicitor General of India. Let me begin the conversation with him. Mr. Luthra, I want to understand from your perspective, when the Vice President says that we have judges with no accountability, is there any merit to that statement?
You heard from a senior lawyer, a respected parliamentarian this time, and holder of a constitution course, the Honorable the Vice President. But I would like to say that perhaps he's missed out the fact that there is a Judges Protection Act. There are provisions in the Constitution, and the Supreme Court had come out with the concept of an in-house inquiry, which has been accepted. Now, the in-house inquiry system is where judges are carrying out an inquiry, and frankly, I think it's unfortunate that we, not just the Honorable Vice President has spoken about it, but a lot of people are indicting the former judge of the Delhi High Court, Justice Verma, while the inquiry is on. The fact is, when an inquiry is on, matter is in a sense sub-determination, not sub judice. It is inappropriate for any of us, citizens or holding any position, to comment about that, because that is an issue where the innocence or lack of innocence is yet to be determined. In this country, we have not given up the presumption of innocence even in a criminal trial, even for the worst offender. So let us keep that basic principle of presumption of innocence, which is a constitutional fundamental principle of Article 21, in mind. That's the first thing. The second thing is, as I said, there are adequate provisions. And to say that judges' FIRs can't be registered, well, the fact of the matter is FIRs can't be registered because there is a Judges Protection Act which is enacted by Parliament. And there are judgments of the Supreme Court in this regard also. So there is, to say that judges' actions are not protected is, I would say, not the entire picture or not the correct exposition of the law.
Okay.
The third thing,
yes.
The third thing is, there is a speech that has been made in a public domain, so to speak. The point is, why mix the incident where an inquiry is pending with the judgment of the court? Let me also make it clear. I'm glad the Vice President made a very important statement. He said, governors, president, vice president are all bound by the oath. They act as per the oath. But I asked this question: was the Honorable Governor in Tamil Nadu conforming to the oath? When the Constitutional Assembly members envisaged the office of a governor, the idea was for the governor to be an interface between the center and the states. The state are, after all, quasi-federal structures or federal structures. Today, when you have a situation where the governor chooses to sit on bills and does not clear them, where the governor acts for considerations which are not in consonance with the oath of office that he has taken, are we expecting our courts to sit silently? Yes, there may be a concern, and that concern will have to be debated as to whether there is a crossing of the Lakshman Rekha on the separation of powers. That matter will be concerned. But the fact is, the government fair and square lost the litigation. Having lost it, it has the ability to go for a review. It has the ability to seek a determination before a curative bench of the Supreme Court. That being the case, why should we speak about these issues in the public domain? Yes, judgments of the court must be debated, must be incisively considered, talked about, critiqued. There is no dispute on that. Nobody is above an intellectual critique. But having lost of it, having lost the case, is it not an issue of sour grapes?
Mr. Luthra, I want to understand, you've spoken about separation of power and there being a Lakshman Rekha, and you say that that ought to be debated, but that's perhaps what the Vice President is saying at this point as well. Who exactly today has the ability to question anything that the courts in India do?
So I think there is a legal process by which we can question what the courts do. I think that's, to say that there is no legal process is absolutely illogical. You as journalists go to the courts all the time for relief. Otherwise, stop going. If you don't succeed, you go in a review. Stop going then. The point is, the president has made a point, but when we, as I said, I mentioned the Lakshman Rekha, but I want to put a query out on your channel. Was the Honorable Governor acting within the norms of the oath he took on the Constitution to uphold the law, to uphold the Constitution? Please let us understand, the Governor is a very honorable and important position in our governance. He is to aid governance in the state. And it is part of his constitutional oath, it is part of his constitutional responsibility. And if a functionary does not aid governance, but appears to obstruct governance, what would you have the courts do? Sit back silently? Today, the court has said the actions of the governor were wrong, and B, the governor must, and therefore these bills must be dealt with in a certain time. Now, that is the matter where the Vice President makes a point to perhaps be considered. Let me also tell you, India is not immune to these things. This happened way back in the 60s when there was the tussle between, if I recall correctly, the Allahabad High Court and the State Assembly. The point is today, the separation of powers doctrine as existed in 1950 has diverted, and there is a lot more overlap that is happening. The Vice President makes a statement that courts are running decisions, running governance. I think there is a point in what he makes, but the question is, why did the executive not provide governance to the citizens? If the executive provides governance, if we enact laws effectively, fairly, and enforce those laws effectively, if we enforce the rights of citizens effectively, then the job of the courts will be less. The courts developed the public interest or the social action litigation concept way back in the 80s. Why? Because it found that the constitutional principles and the fundamental rights were being violated. They found that there were people who were not having access to justice. Our preamble talks about equality, social, political, both economic, political. So we need to look at social equality, we need to look at political equality. The fact is that concept is still a work in action.
Okay.
And therefore, the courts have acted to ensure governance, social justice, economic justice, and political justice. And this, I believe, is a case of ensuring political justice.
Okay, Mr. Luthra, coming back to some of the comments that the Vice President has made about the judiciary itself, particularly referring to the Justice Verma case, do you feel that the courts have in a way addressed concerns that were raised after the Justice Verma case regarding the accountability or the impunity with which judges operate in India?
I think that's a very strong word you used. Did you say impunity? Did I hear you correctly saying impunity?
Yes, sir. That's what has been inferred from the Vice President's statement by many people. I'm simply posting the question. This is not my statement.
Fair enough. No, I'm a little surprised by the use of the word, but I think it's unfortunate that we use the word impunity. So let me explain to you. The judiciary, it was recognized in the American papers, the Federalists, way back in the 1800s, that the judiciary is the weakest of the institutions of governance because it needs to use the other institutions to enforce its orders, and therefore it must have the maximum protection. Therefore, when the constitution was framed, we brought in a protection position where judges holding constitutional posts could not be removed unless 100 members of parliament in the Lok Sabha and 50 members of parliament in the Rajya Sabha, and incidentally, the Honorable the Vice President is Vice Chairman of the Rajya Sabha. Now, the only if a motion is moved by 50 in Rajya Sabha, 100 in Lok Sabha, then and only then can a motion to remove a judge be made. However, the Supreme Court evolved a mechanism where they have a system where you have an in-house inquiry which is right now underway, and therefore I feel to indict an individual while the inquiry is underway is, to say the least, presuming guilt when the person is not yet proved to be guilty, and that is how the system of law works in this country for all of us. Thirdly, I told you there is a Judges Protection Act. Let us not forget that. Now let me come back to the issue of, you use this term that judges act in a manner which is, let you use the word impunity, which I'm a little disturbed by, but anyway.
I will once again repeat myself, sir. It's the inference that has been made.
Look, once you've used the word, let's deal with it for a moment.
No. All I'm trying to tell you is I've not used the word. It's the inference that has been drawn by several people, made by the comments by the Vice President.
Ma'am, look,
yes, and I'm just posing that question to you.
And look, the fact is the word is used, so we must deal with it. It's a very strong statement to be made. The inference is very strong, and I'll tell you why the inference is not justified.
Yes, surely, go ahead.
The fact remains, please look at the Constitution for a moment. Please look at the Constitution. There is a schedule to the Constitution which talks about an oath which people take on the Constitution. If you ever have look at that, it talks about performing your duty without fear or favor. And let me just deal with this for a moment. And I think it's important for me to point out what is the nature of the oath that is taken. Now, a judge of the High Court is to take an oath, or the judge of the Supreme Court, etc., to bear true faith and allegiance to the Constitution, and I will uphold the sovereignty and integrity, and I will duly and faithfully and to the best of my ability, knowledge and judgment, perform the duties of my office without fear or favor, affection or ill will, and that I will uphold the Constitution and the laws. So if you don't find a judge upholding the Constitution and the laws, a judge upholding his oath palatable, then that should not be the subject matter of such strong terms or strong use. And let me also point out, similar are the oaths that are to be taken by various functionaries under the Constitution. It is not that the governor is bereft of taking a similar oath or similar commitment.
Okay.
And when you take an oath, just hold on. When you take an oath to uphold the Constitution and the laws, any functionary, what do you mean? What does it mean? It means you act in aid of governance, you act in aid of ensuring that the citizen is protected and the citizen's interest is served. And that's what the court has asked you to do.
Okay, all right, Mr. Luthra. Thank you so much for joining us on NewsX with your perspective. I'm also being joined at this point in time by Senior Advocate Kailash Vasdev of the Supreme Court. Mr. Vasdev, I begin by asking you, how do you view the Supreme Court verdict, which has fixed a timeline for governors and the president to decide on state bills?
Look, it's not a verdict of the Supreme Court. These are versions so far. What the Supreme Court is saying is, are you speaking of the presidential order or are you speaking of the Waqf proceedings? Hello?
Yes, Mr. Vasdev. Could you repeat yourself? Are you asking?
You're speaking of the order on the governor and the president, or are you speaking of the Waqf?
The order on the governors and the president, sir. Not on the Waqf.
It's like this. These are directions and these are requests made by the court in its judicial functioning. It says that don't delay these matters because these are matters which are decided by the legislatures, and holding consents or whatever it is a discretion of the governor. To hold back a consent for so long is also incorrect because you are dealing with elected representatives. And in the doctrine of separation of powers, you have three distinct areas: legislature, executive, and judiciary. The judiciary oversees the functioning or tests the functioning of all the others. The legislature makes the laws, the executive decides to implement them. If there's a delay in implementation, the judiciary says you must choose to do so and do it at the earliest. I see nothing wrong about it. Now here there is a bit of a caveat which comes in. The functioning of the judiciary itself is now coming under a lot of cloud. You've had exposures of judges with corruption and so on and so forth, and we are taking it upon ourselves to decide matters. We are in deciding a matter, the court is doing its judicial duty or its constitutional function, whether it's the Supreme Court or the High Court. They're supposed to do it, they're doing it, the judicial review. But on the other side, when you're looking at the functioning of the judiciary by itself, that's another area which needs to be cleaned up. See this recent case of cash being found. Nothing has happened in 1 month. You are giving out an impression that you are a superpower where this situation is getting from back to us. So therefore, please divide this whole functioning into two distinct areas. Judicial review, you have a judicial constitutional duty, you are bound to do it constitutionally. Within your own house, please clean it up. You are giving an impression to people and giving them a handle to say things about you which are uncalled for. So these are two distinct areas we have to look at in different types. The recent observations, judiciary is exceeding its brief and going beyond its jurisdiction. Well, these are statements which are bound to come considering the circumstances in which we are getting placed.
Mr. Kailash Vasdev, I want to understand from you, you've spoken about cleaning up your own house as far as your advice to the courts is concerned. We were just speaking to Mr. Siddharth.
Sir, you're not very audible, ma'am.
Sir, can you hear me?
Yes, I can hear you. Yes, go ahead.
Yes, you've just spoken about your advice to the courts would be to also clean up its own house, and you've spoken about the pace at which the Justice Verma inquiry is going on. We were
Yes.
just speaking to Mr. Siddharth Luthra as well, who took very strong offense to a term that is being used by people in society today, is that judges do move around with impunity. How does the Supreme Court then, or what is it that shall be done to perhaps ensure that there is no damage that is caused in the minds of the people vis-a-vis the judiciary in India?
Look, that's an area which is now becoming the issue of the day. We have to, within our judicial system, come out and show that we are doing things to rectify the house. Imagine this episode takes place at Holi. We are speaking a month down the track. Nothing tangible is arriving in it. And it's a very serious matter of a judge having such large volumes of cash lying in the house. And look at the kind of impression people, if this had happened to an ordinary person, my God, they would have come hammer and tongs on the person. You would have had CBIs and God knows what not and where not, FAI, everything working on it. People would have been arrested, directions would have been issued. But here we are trying to do something which is not making sense to me anymore. Either you hand it over to somebody to investigate independently if you're not finding an answer within yourself. If you're finding an answer within yourself, then please tell us what you're doing. What is the consequence of it? You can't transfer a judge from one place to the other on these allegations. It doesn't make sense. On the other side, in your judicial functioning, you're doing what you have to. Your judicial decisions will now become a matter of comments by everybody. And that is where the sad situation arises, the loss of faith in the system. That loss of faith is something which the judiciary must wake up to. Cases pending for 20 years, 30 years, 40 years, granting bail to some, not granting bail to the other, giving relief to some, not granting relief to the other in the same set of facts. See, these are matters which need a lot of introspection today. That's my view. 50 years I have spent as a lawyer, and every day we think of stories, we think of situations, and we are not able to find solutions to it.
Absolutely. Mr. Kailash Rajdeep, thank you so much, sir, for joining us on the broadcast with your perspective on the debate that has now been ignited by the Vice President. I'm also being joined on the broadcast by Mr. Rakesh Sinha, who joins us with his perspective, former member of Rajya Sabha. Mr. Sinha, I want to understand from you, how do you view the Supreme Court's verdicts fixing a timeline for governors and the President to decide on state bills?
I think President of India is not only the highest office, but morally and constitutionally, his position is unchallengeable, uncontestable. The President, whosoever may be, the office symbolizes the sovereignty of the country. Although it is a parliamentary democracy, but we are a republic, where every act, every pact, and every executive action is endorsed by President of India. It may be symbolically or substantially, but this is the reality. When the court questions the President of India, this itself involves the constitutionality of the court itself. The constitutional bench of the Supreme Court must decide the limit of its intervention. It can intervene the Parliamentary Act. It can intervene on constitutional questions. But can it dictate and guide the President of India? As a student of politics, whatever my understanding is, it is a very abnormal circumstances when it dictate, it can guide. It can suggest certain measures that the act of the government is like this and that. But it cannot question even the pocket veto of the President of India. Gyani Jail Singh used the pocket veto when Rajiv Gandhi government brought the postal bill. This bill was against the freedom of expression and basic constitutional right of the Indian citizen. At this juncture, Gyani Jail Singh was definitely a part of the Congress family. As a President of India, he thought that he should use this pocket veto. There are so many occasions when President killed the bills. Now, if the Supreme Court thinks that it can even intervene, it can question the pocket veto, then I don't know how the experts of the Constitution would analyze, give their opinion. This is very subjective, very controversial, and as a student of politics, I again say that the non-elected part of the government must honor the elected part of the government. We are accountable to the people. We represent the aspirations of the people. We are directly connect with the people 24 hours, 365 days. Here we require that our actions should be constructively guided by the Supreme Court, constructively. And I hope that this question would be deliberated by largest section of the people, and I honor the Supreme Court, the honesty, integrity, and its role in the modern India is very significant and vital. In that tradition, I think Supreme Court judges would decide how long and what extent they can intervene the President's office of the President of India.
All right, but Mr. Sinha, I also want to understand from you, do you agree with the statement made by Vice President Dhankhar that rulings such as these are an overreach by the Supreme Court?
Vice President of India, Honorable Sri Jagdeep Dhankhar ji, himself is a constitutionalist. He is a great lawyer, and he is very, very acknowledged intellectual in the country, besides being the holding the constitutional office of the Vice President of India. His role, his background, his spirit to defend the Constitution is known to everybody. So he is a part of the constitutional mechanism of the country. So his opinion must be taken very seriously, very constructively, and Supreme Court must honor his opinion. His opinion is not an opinion of a common citizen. He himself is a constitutional authority. He himself is a constitutional expert. He himself is a part of the judicial bodies. He has been part of the judicial bodies. He has been a great lawyer. So I think his opinion is possesses some values which need.
Okay, Ms. Sinha, last question to you. How do we then draw the line between what is perceived as judicial overreach and at the same time not create an environment or scenario where perhaps the president's office cannot be scrutinized by a court?
You know, I not only me, but everyone who knows the Constitution, who knows the India's republic, also know the fact that India is a republic. It is a republic that because the highest office of the institution is also elected, not nominated, not co-opted. Unlike the British parliamentary democracy, when kings and queens, who are non-elected people, hold the highest office, still enjoy the maximum privileges. In India, the President of India is indirectly elected by the people. He or she is elected by the votes of the assemblies, parliaments. Therefore, questioning the President of India, who symbolizes the sovereignty of the country, who symbolizes the republicanism of the country, who symbolizes the office which rules the country. In fact, I told earlier that every pact and every act is signed by the President of India. And even the Supreme Court judges, even the Chief Justice take oath. And you know, when you are questioning the President of India, scrutinizing the President of India, this means you are dismantling the entire constitutional scheme. You are dismantling the republican scheme of the country. It is very unfortunate. Check and balance should not go beyond a certain limit. Of course, in our democracy, there is a check and balance, executive, legislature and judiciary. And I say that judiciary has played a very great and significant role. When judiciary takes a conservative position, it is parliament which guides and dictates judiciary. On the question of Jamindari abolition, judiciary had taken a very conservative approach, and then the parliament came forward and amended the constitution. There was a confrontation between the parliament and judiciary. We have seen the issue of Keshavananda Bharati case and Golaknath case, when the basic structure of the constitution was interpreted by the larger constitutional bench. There are so many occasions. So it is not in democracy, it is not the black and white. It is a cooperative and constructive approach to a particular issue at a particular time. Therefore, I hope that Supreme Court must take into account the civilizational perspective of India, one. Second, the spirit of the freedom movement, two. Number three, the spirit of the emerging social movement in the country, cultural aspiration of the country. You cannot suppress the cultural aspiration. Moreover, the unity and integrity of the country should not be challenged in the name of the freedom of expression. It should not be crushed, taking pretext of the constitutional provisions. Constitutions are made to unite the country. Constitution should not be misused to disunite the country.
All right, Mr. Sinha, thank you so much for joining us on NewsX with your perspective on the same. With that, viewers, we sip into a very quick break.